Hello, legislation class. Welcome to part 2 of our discussion of extrinsic sources of interpretation. In this discussion, we'll talk about the in pari materia canon, the dog that did not bark canon. We'll talk about the use of subsequent legislative history. We'll discuss presidential signing statements, legislative inaction and acquiescence, and statutory clashes and the possibility of implied repeals. So the first case that we had to look at in this section was the Montana Wilderness Association case. And this is another checkerboard case. Remember that the checkerboard cases are about a land grant scheme when the railroads were expanding west, and the government would grant to the railroad a parcel on which the tracks could be laid, and then the government would maintain an alternating parcel in a checkerboard pattern. And so this case involves land located in Montana that a successor of one of those original railroad grantees now owns, and the land is valuable because it contains timber, and the company wants to build logging roads through the public land, and there are a number in order to reach the parcel that contains the timber. And there are a number of environmental advocates and other groups who are trying to block the access roads across the public land. A lower court had held that Burlington Northern, this successor, held an easement by necessity or an implied easement to access the totally enclosed timberlands for logging. And in its first opinion on the case, the Ninth Circuit reverses. The Ninth Circuit ultimately says that the governing statute here does not give Burlington Northern any kind of implied easement. And if you think about it, this is the reverse of the situation of the previous checkerboard case that we had looked at. So one of the arguments that Burlington makes is that there is a later statute, the Alaska National Lands Conservation Act, which actually is passed even after the district court's initial decision. And Burlington argues that this Alaska statute provides an independent ground for affirmance. And we have here the language of that Alaska statute. So the first part, subpart A of the relevant part of the statute, said that lands within the National Forest System could be given access as the secretary of the relevant agency deemed appropriate. So National Forest System is really the operative phrase there. But subsection B of the statute makes clear that it only applies to Alaska, lands in Alaska. And so, of course, the case we have here is land in Montana. And the question is, well, does this statute that seems to relate to land in Alaska, but also says National Forest System, encompass land in Montana? And in this first opinion, the Ninth Circuit says no. The National Forest System in the Alaska statute has to be read in pari materia with section B. So subsection A of the statute that says National Forest System is in pari materia with section B, which refers to Alaska. There's no other provisions in this particular statute that have nationwide application. So applying this in pari materia canon, the Ninth Circuit says the reading would be that National Forest System only applies to forests within Alaska. Now, Burlington points out some legislative history, and some of this legislative history is the remarks of one senator that is made actually after the passage of the act that seems to suggest that subsection B applying to Alaska actually does have national implications in virtue of subsection A. But here, the Ninth Circuit says, well, that's just the understanding of really one senator. It can't be the understanding of the Senate as a whole. So we see this familiar tension of what do particular kinds of legislative history or extrinsic sources of interpretation actually mean? What is their value in trying to understand what the legislature as a whole says? Further, there was some language in an Energy Committee report that Burlington claims support its position, and again, here the court says this really is ambiguous language, it's not clear, and in light of the seemingly express limitation in subsection B to Alaska, it wouldn't apply. The Ninth Circuit also then applies this dog that doesn't bark canon. So remember, this comes out of a story from Sherlock Holmes. So Sherlock Holmes is trying to solve this crime, and he observes that there's a guard dog on the property, and the evidence is that the guard dog was not barking on the night of the crime. So from that, Sherlock Holmes deduces that the criminal must be someone who is familiar to the guard dog, that is, an insider. If it was an outsider who wasn't familiar to the dog would have barked. And the idea here is, if you expect there to be some noise, if you expect some noise to be made about something, if you expect Congress to have raised something or the statute to say something, and they don't, then that seems to suggest that particular thing doesn't apply. And here the Ninth Circuit said there were many opportunities to discuss the change, a national change, to access to these checkerboard lands for forestry purposes, access across the public lands to get to enclosed forested lands. But there is no such discussion in the statute or anywhere clearly in the legislative history that the Ninth Circuit could find. So the Ninth Circuit therefore concludes that the dog that didn't bark is this application, this national application of the statute. Now, Burlington points to one other piece of evidence, which is an exchange of letters by two congressmen, again, seeming to suggest that perhaps there is some national application. But here the Ninth Circuit says, well, these are off-the-record exchanges of views. It's not uncommon for congressmen off the record to exchange views about a piece of legislation. Maybe they're trying to cut a legislative deal. Maybe they're just otherwise having some discussion about it. But all that reflects is what two particular congressmen were discussing at some point in time, the court says, not what Congress overall might have thought. And here, even the House as a whole, the legislative body as a whole, doesn't seem to have even been aware of this particular correspondence. So at this point, the Ninth Circuit has said, no, there is no national application in this Alaska statute, and there's no other evidence in the checkerboard scheme that there would be an implied easement over the public land to get at enclosed forested land. But there is subsequently an intervener who convinces the Ninth Circuit to rehear the case. And this is, pretty unusual to get a court ever to rehear a case, and unusual for an intervener to be able to get a court to rehear a case. It does happen when there's new evidence or new law or something like that that is discovered, but it's relatively rare. In any event, here in this case, the court does agree to hear it, and the additional evidence that's presented relates to legislative history and subsequent legislative history and subsequent legislation to the Alaska statute. And so the court here kind of reiterates the idea that, yes, indeed, Section A and Section B of this Alaska statute are in pari materia, that this does seem to suggest that where it talks about national forest system, that is limited to Alaska. And this tips it in one side, but the court says, here's some additional information that we've learned. And what we've learned is that there's a Colorado statute, which is similar to the Alaska statute. And to get a little bit of a feel for what's going on politically and in the regulatory sense, while all this is happening, you have these old checkerboard lands. You have some of these lands being enclosed or difficult to, really difficult or impossible to get to without some kind of easement over public portions of the land. And some of these checkerboard lands are rich in natural resources like timber. So think of the places we're talking about: Montana, Colorado, Alaska, right? Timber, minerals, things like that. You can see how some of the environmental community might not want to allow the access over the public lands, both not to degrade the public lands, but also not to allow the extraction of those resources, even from the privately held lands. And you can see how the private entities want that access, and you can see how some might argue for deregulation in a sense, or at least provision of this access so that the resources could be extracted. So this is a period when Congress is looking at different statutes in different states with some of these resource-rich checkerboard lands and deciding to give access. They did it in Alaska. In Colorado, they decided to do it as well. And in the process of doing this in Colorado, there's discussion about, well, should we in this statute make this a national thing? And the decision is made not to add national language because the Alaska statute, it was assumed, already includes national language in its reference to the National Forestry Service. So this legislative history of the subsequent Colorado statute, the Ninth Circuit now says, is relevant to the interpretation of the earlier Alaska statute, in that the overall scheme of Congress is actually to provide a national ability to provide some access to these kinds of lands. And, the court has some limiting language. This is not entitled to great weight. You can't use this kind of thing the same way in every case, but it can be persuasive, and it proves persuasive in this case. So these two Montana wilderness cases illustrate an interesting dynamic between a few of these different kinds of canons, speaking about legislative history, speaking about in pari materia, and you can see how these things work together, how a court might try to balance them out, and how kind of the underlying context might influence the way the court applies some of these different tools. The second piece of this section was our discussion of presidential signing statements. And so recall the discussion we had in class that in the federal system, in the U.S. Constitution, we have a requirement of bicameralism and presentment. Both the House and the Senate have to pass the same statute, the same bill. That bill goes to the president, and the president can either sign it into law or veto it, up or down, the entire thing. There is no line item veto by constitutional design as the Supreme Court has interpreted the Constitution at the federal level. Some states have line item vetoes, but at the federal level we do not. So what presidents began doing, starting really with President George W. Bush and used often by the Obama administration, and as we saw in class now used in some occasions by the Trump administration, is to sign something into law but adding to it an interpretive statement by the executive saying, well, I think this provision means this. I think this provision is constitutionally problematic if interpreted a certain way. We looked at this in class in the context of a military appropriations bill that really funded the military, and that so therefore was a lot of pressure on the president to sign it into law, but that had some provisions that the president thought limited his authority as commander-in-chief. So the legal interpretive question is, what effect, if any, do those statements have? And one argument would be the executive is a co-equal branch of government. The evidence of what the executive thinks the legislation meant when he or she signed it ought to be relevant to interpreting it. Another view would be, yes, the executive is a co-equal branch of government, but the executive's role with respect to legislation is limited by constitutional design, either to giving it the thumbs up or thumbs down, either signing it into law or not signing it. And the only really relevant intent would be Congress's intent. And to the extent legislative history is relevant at all, and again, that depends on your view of textualism, the only intent that would be relevant would be that of Congress. We don't really know how courts will deal with this. We really haven't seen cases directly addressing the weight of presidential signing statements. It's just something else to keep in mind, given that this has become an increasingly important practice. And we'll be curious to see kind of how courts deal with this and think about how you might deal with it. The next thing we looked at in this unit was legislative inaction or acquiescence. And here we looked back at the Bob Jones versus United States case. And we've looked at this case before in the context of kind of historical background and change in historical circumstances. And remember, this case involves a private religious university, Bob Jones University, which had a nonprofit status, a 501c3 status. And the Bob Jones University had a policy of prohibiting students and faculty and staff from interracial marriage. And so if a student or a faculty or staff member became married to someone of a different race, they would have to leave. And they had this nonprofit status, and the IRS came out with an opinion and then applied it against Bob Jones University, saying that racial discrimination of this sort would be enough to revoke the charitable status of an institution like Bob Jones. And Bob Jones argued all the way up to the Supreme Court that this was an inappropriate interpretation by the IRS, that the statute itself that defines who is entitled to a not-for-profit exemption simply says a corporation organized and operated exclusively for religious, charitable, a number of other things, or educational purposes. And Bob Jones argued that there was really no dispute that they were in fact a religious institution, they were in fact an educational institution. And it might be that the IRS or other parts of the federal government or other people might disagree with their stance about certain things like interracial marriage, but that didn't change their character as a religious or educational organization. So if you remember when we first looked at this, we looked at Justice Berger's opinion for the majority, and Berger said allowing a charitable exemption for an organization that engages in something like racial discrimination would be contrary to the developing historical meaning of the word charity. And remember then we also looked at Justice Rehnquist's dissent, kind of contradicting what the historical meaning of charity might be. But that's sort of the one main line of the decision, is this idea of what's the historical meaning of charity. Further, and this is the part that we're looking at for this unit, Justice Berger says, since the IRS first in 1970 came up with its ruling that institutions that engage in racial discrimination are not charities, 12 years had passed from that time to the time that this case got to the Supreme Court. And Congress had plenty of opportunities and in fact considered bills that would preclude the IRS from taking this kind of action, that would cement the fact that the definition of a charity would include any kind of bona fide religious belief, even if some people think that belief might in some way be discriminatory. But Justice Berger said that Congress didn't do that, and the fact that Congress didn't do that is a kind of acquiescence. Berger says, this is not always a helpful guide. It may be that Congress doesn't act for all sorts of political reasons or other reasons that have nothing to do with the merits. But here he thought the non-action was significant. It was an important policy issue, and if anyone was going to act on it, Congress would have, so that the court is justified in saying that the IRS's ruling has some additional weight. Notice here that we've got another example of the interplay between the legislature, the statute, and the administrative state. We will be talking more about that throughout the last part of the semester, but this is one example of how the legislature not acting once it has empowered an agency to act and the agency has acted in a certain way could be relevant to a court. Now again, we have a dissent on this point from Justice Rehnquist, and Justice Rehnquist says, well, I think this doesn't have any particular interpretive significance at all. Congress, for any number of reasons, might not have acted, and that might have nothing at all to do with the merits of the IRS's interpretation. And effectively, Justice Rehnquist is saying it's the role of the court to look at the actual language of the statute and to say if the agency, in fact, has acted in accordance with the statute or not. And for Rehnquist, the statute was pretty clear about what kinds of organizations it included or didn't include. So here again, you can see this kind of interplay of acquiescence or legislative inaction. I think it's fair to say that courts are generally reluctant to infer very much from legislative inaction because of all the reasons that a legislature might be incapable of action. But there might be cases like this one where it supports a result and the court might apply that kind of reasoning. So So the last issue we looked at in this unit is statutory clashes and implied repeals, and we looked here at the Morton v. Moncari case. So the issue in this case was a apparent conflict between the Wheeler-Howard Act, which was a 1934 statute providing employment preferences to Native Americans, and the Equal Employment Opportunity Act of 1970, which was a general, broad employment non-discrimination act. And so you have in this case some non-Native Americans who claim that they were not able to obtain a certain government job because of preferences given to Native Americans under the Wheeler-Howard Act, and they claim, the plaintiffs claim, that this violated the later Employment Non-Discrimination Act. And effectively, the court said, what the plaintiffs are arguing is that the 1970 Employment Non-Discrimination Act implicitly repeals the Wheeler-Howard Act. There was no express repeal, but that it implicitly repeals it. And the court lays out the general rule, which is the general rule, that a repeal by implication is not favored. What courts generally want to see, if there's going to be a repeal or an amendment or a modification of a prior statute by a later statute, is to have Congress spell that out, to have the legislature spell that out. It's relatively easy enough for the legislature to do that if it wants to do that. It has a pretty important effect, obviously, because there is a law on the books. There's a statute on the books that is doing something. And then to say that is no longer law, you ideally want the later law, the legislature in the later law, to actually say that. Now, that doesn't always happen. Sometimes there is just this operational conflict, which perhaps requires a court to say, yes, indeed, these two things can't work together, and I need to either say there's some kind of implied repeal, or this creates some kind of constitutional conflict, or it creates some kind of absurd result, and to try and find, and if necessary, to say perhaps the earlier statute is not operative. But courts don't want to do that. And in particular, and this relates to a number of the canons we've looked at, including the canon against absurdity, there's this general presumption, even if it's often an unrealistic presumption, that Congress is acting rationally, that the entire U.S. Code is rational and works together and fits together and is a coherent body of law. Now, we know that's not necessarily always the case. Often it's not the case. We know the making of the sausage can be ugly, and it sometimes comes out a mess. But this is a general principle that courts apply really to uphold kind of the integrity and functionality of the statutory law. And in particular, courts will try to find ways to harmonize if there are different policies that they can work out. So here, in a sense, it was relatively easy for this court because there is, of course, the dark history of the expansion westward and the appropriation of Native American lands and the poor treatment of Native Americans, and then subsequently some recognition of that by Congress and some remedial legislation like the Wheeler-Howard Act and other later statutes as well, that were designed to provide preferences and other things to remediate past discrimination against Native Americans. And the court here says, well, that's not inconsistent with a broad non-discrimination statute. We have a broad non-discrimination statute, which is also in its own way remedial because of racial discrimination and gender discrimination and other things along those lines. So we want to fix those things and say, generally speaking, no discrimination based on race or national origin based in employment. But on the other hand, some groups like Native Americans who've historically been disadvantaged might actually get a preference in some circumstances. That's not necessarily contradictory. It reflects an overall policy of remedying past racial and national origin discrimination. And so this court says that what it's going to try to do is, unless really Congress expressly says so, not find that there's a repeal. So these are the principles that and cases that we covered in this unit, and I will see you in class.